Welcome to the fourth and final module on expulsion of EU citizens. As we saw in the previous training modules, EU free movement permits EU citizens and their family members to move freely within EU member states and to reside there under certain conditions. However, EU law also provides member states with the power to expel or deny entry to mobile EU citizens and their family members. The conditions for expulsion, as an exception to free movement, are strict. During this training module, we will discuss in detail what the legal grounds for expelling mobile EU citizens are under EU law. There are three main types of grounds. 1. Public policy, public security and public health. 2. Loss of residence rights. And 3. Fraud or abuse of rights. Let's look at public policy, security and health first. These grounds mainly apply to criminal activities and socially harmful behaviour. These grounds for expulsion are also applicable to EU citizens who are legally residing in the host member state. Next, let's look at loss of residence rights. These grounds essentially apply to economically inactive persons who lack sufficient resources, that is to say, mobile EU citizens that don't fall into any of the statuses for legal residence. They never apply to workers, for instance. Finally, there is fraud or abuse of rights. These grounds correspond to cases of falsification of documents or marriages of convenience. These grounds, as with public policy offences, also apply to all mobile EU citizens, irrespective of their status in the host member state. In some cases, these grounds have been used to target homeless and destitute mobile EU citizens specifically. Public policy grounds were used in Denmark against people who were begging, and in France against Roma people. Lacking a right to reside has been used in Belgium against economically inactive EU citizens who were in receipt of welfare benefits and were regarded as an unreasonable burden on the welfare system, and were therefore served with an order to leave the territory. Abuse of rights has been used in France against EU citizens moving with the primary purposes of benefiting from the welfare system, and in the UK against rough sleepers. We will see in more detail later how these grounds have been used in practice to justify expulsions. Before that, though, we will need to discuss the minimum safeguards that EU citizens have against expulsion by the host member state. Once EU citizens are expelled from an EU member state, they must be able to re-enter the territory of their member state of origin, the member state of which they are nationals, without undergoing any formalities. They can also re-enter the member state that expelled them, unless they were the object of a re-entry ban. A re-entry ban is a prohibition on entering the territory again. The authorities of the expelling member state may only adopt a re-entry ban in the event of expulsions carried out on the grounds of public policy or public security. This means that a person expelled for loss of residence rights may always re-enter the member state from which they were expelled. Expulsions are generally actioned in the form of an expulsion order. The EU has set some minimum requirements for expulsion orders issued by member state immigration authorities. An expulsion order must be done in writing and must include a full explanation of the reasons for the expulsion and its implications, the time limit for lodging an appeal and the court or administrative authority with which to lodge the appeal, the time by which the individual concerned must leave the territory of the member state. National authorities may decide how much time to grant the person between the notice of expulsion, i.e. the date when the person receives the expulsion order, and the enforcement of the expulsion. However, the EU has set a minimum amount of time that must pass between the notice of the order and its enforcement. Except in urgent cases, the time allowed the person to leave the territory cannot be less than 1 month from the date of the notice. Urgent cases give the immigration authorities the discretion to shorten the 1-month minimum period. However, when invoking the urgency of the case, the national authorities must consider the impact of an immediate removal on the personal and family life of the individual concerned. This means that they must take into account the implications for that person and for the family of an accelerated expulsion. such as the need to give notice at work, to terminate a lease, to arrange for personal belongings to be sent to the new place of residence, and the children's education. After notification of the expulsion, will the EU citizen in question be able to access social benefits in the time between the notification and the enforcement of the expulsion? When expulsion is based on loss of residence rights, no, because having a right to reside in the host member state is the main condition to enjoy access to social benefits on the same conditions applicable to the nationals of that member state. In the case of expulsions based on public policy or on abuse of rights, the mobile EU citizen should in principle keep, upon enforcement of the expulsion, the social benefits she or he is entitled to if they are still legally residing in that member state. Let's go back to the 3 grounds mentioned earlier that may justify an expulsion of a mobile EU citizen. Do you remember which were the first grounds that immigration authorities can invoke? They are the grounds of public policy, public security, and public health. In this context, we won't consider public health because these grounds, rather than being used as a basis for expulsions, have mostly been used to justify restrictions on the entry of EU citizens, as for instance was the case in many EU member states during the recent pandemic crisis. Public policy and public security are probably the most typical grounds used to justify the expulsion of a mobile EU citizen. The concepts of public policy and security are established at national level by member states in accordance with their needs, which can vary from one period to another. This means, for instance, that what is considered a threat to public policy in one member state may not be the same in another member state. This also means that the same member state may regard as a threat one type of behaviour at a particular time, but this may not be the same at another point in the history of that country. Criminal offences change over time as society evolves. What does public policy cover? Public policy aims to prevent disturbance of law and order. Criminal offences, unlawful possession of drugs, violent actions to overthrow the order of the state, or other socially harmful behaviours have all been recognised as legitimate public policy concerns. And which behaviours are covered by public security? Public security covers the internal and external security of the member state. Terrorism, human trafficking, sexual exploitation, drug and arms trafficking, money laundering, corruption, counterfeiting means of payment, computer crime, and organised crime might all be regarded as grounds for expulsion related to public security. We said earlier that expulsion on the grounds of public policy and security applies to any mobile EU citizen, irrespective of their status. This means that legally resident mobile EU citizens, such as workers, family members, or students, may also be expelled if they are considered a threat to public policy or security. However, the EU legislator considers that it is different to be expelled from a country if you've been living there for a few months or if you've been living there for several years. This is the reason for the different application of expulsion on the grounds of public policy and security, depending on the length of time the person concerned has been legally residing in the host member state. The principle is quite simple. The longer a person has been residing in the host member state, the stronger the safeguards against their expulsion. If they've been living there for less than 5 years, the person may only be expelled from the member state if their personal conduct represents a genuine, present, and sufficiently serious threat to one of the fundamental interests of society. If they've been living there for more than 5 years, the person may only be expelled on serious public security or public policy grounds. If they've been living there for more than 10 years or are a minor, the person may only be expelled on imperative public security grounds. All these concepts, genuine threat, serious grounds, imperative grounds, are quite vague. What is important to bear in mind is the principle. The longer the person has been residing in the member state, the more difficult it should be for the authorities to justify their expulsion. Mobile EU citizens who've been living in the host member state for more than 10 years or that are minors can only be expelled for imperative reasons related to public security. This means that only serious criminal acts that endanger the national security of the member state can justify the expulsion of minors or residents for more than 10 years. To give an example, trafficking in narcotics as part of an organized gang, human trafficking, and child sexual exploitation have all been recognized as criminal offences covered by the concept of imperative grounds of public security. National authorities have the power to assess the seriousness of the threat to public policy or public security on a case-by-case assessment basis. But what are the general factors that need to be considered when assessing a threat to public policy or security? Firstly, the nature and seriousness of the offence. Secondly, their frequency and the time elapsed since the offences. Is there some proof of good behaviour since then? Has the person been released on parole? Thirdly, the damage or harm caused. And fourthly, the degree of social danger resulting from the presence of the person in that member state. Past conduct, previous criminal convictions, or imprisonment should not in themselves constitute grounds for expulsion and can only be regarded as evidence of personal conduct where there is the likelihood of re-offending. A single disruption of the social order by breaking the law, such as possessing drugs for personal consumption, prostitution, or begging, is not enough to warrant a threat, but persistent petty criminality may represent a threat to public policy. The risk of re-offending may be considered greater for a person who is dependent on substances, if the person is likely to commit further criminal offences in order to fund their dependency. Is the collective expulsion of mobile EU citizens of Roma origin found to be living in illegal settlements or in abandoned flats without financial means in line with EU law? The answer is no. A collective expulsion is always illegal because it does not take into account the personal conduct and the background of the individual concerned. In addition, illegal occupation of property, even if considered a criminal offence in some member states, is not sufficient to qualify as a threat to public policy. A Bulgarian citizen had been living and working in Denmark for a few years. He lost his job and ended up sleeping rough and begging on the streets of Copenhagen. He was arrested and received a deportation order because he was regarded as a threat to public policy. Was this expulsion in line with EU law? First, it is doubtful that rough sleeping and begging can be regarded as behaviours that endanger the public policy of a country. Secondly, even if begging or rough sleeping may sometimes be regarded as an offence, expulsion must not be an automatic consequence of that offence. The immigration officers involved in that case did not consider the personal conduct, the length of stay, or the social integration of that person in Denmark. A and Z are both Italian citizens living in Germany and have both finished serving their 2-year sentence for robbery. This was A's first conviction, and since leaving prison, she has found a job. She does not represent a genuine, present, and sufficiently serious threat to the country to warrant being expelled from it. An expulsion in this case is contrary to EU law. On the other hand, this was Z's fourth conviction, and within less than 2 weeks, she was caught planning another robbery. Her conduct may be regarded as a threat to public policy and therefore sufficient grounds for expulsion. Once the authorities have established the existence of a threat, they must also assess whether the expulsion is appropriate or whether less stringent measures could be employed. Member States must consider the personal situation of the individual concerned and, in particular, their length of residence and social integration in the host member state, family links or language skills, for example, their age and health, the impact of the expulsion on other family members who have a right to remain that's based on theirs, and their links with their country of origin. Let's look at a case study on proportionality. The expulsion of a French citizen who was raised in Germany from an early age and who does not speak French may be considered disproportionate because of the lack of ties they have with the member state of origin and the strong ties they have with the host member state. On the contrary, the expulsion from Germany of an Italian citizen who committed the same crime but who has only been living in the host member state for a few months could be considered proportionate. Now that we have discussed expulsions on the grounds of public policy and security, we can look in more detail at expulsions for loss of residence rights. In the previous training modules, we said that after 3 months of presence in the country, only mobile EU citizens that have a specific type of status are allowed to remain in the host member state. Do you remember which statuses these are? They are essentially being economically active, having sufficient resources, or being the family member of a person that has one of these statuses. Expulsions for loss of residence rights are therefore never applicable to workers, self-employed persons, or job seekers. These grounds only target economically inactive mobile EU citizens who do not have sufficient resources to support themselves and that are regarded as a burden on the welfare system of the host member state. Simply not having a status that grants legal residence in the host member state is not enough to warrant someone being expelled. Only economically inactive persons with no resources that are considered a burden on the state may be expelled. Being a burden, as we will see later, essentially means claiming welfare benefits in the host member state. Let's see some examples of the application of expulsion for loss of residence rights. Economically active persons and their family members always retain their right of residence, and in no event should they be expelled on grounds related to residence conditions. Let's take a simple example. Matteo, an Italian citizen, entered Germany to seek employment and found a job. He and his family members may not be expelled as long as Matteo keeps worker status. If Matteo loses his job and he is not able to retain worker status, he can still register as a job seeker and so will be protected against expulsion as long as he demonstrates having a genuine chance of being employed. During the first 3 months, economically inactive persons retain the right to reside as long as they do not become an unreasonable burden on the welfare system of the host member state. However, under EU law, these persons are not entitled to welfare benefits during that time. Only a repeated and protracted use of welfare assistance would justify an expulsion during the first 3 months of that person staying in the host member state. In practice, they are generally not allowed to apply for welfare assistance in the first place. After 3 months, economically inactive persons with sufficient resources, or students, retain the right to reside as long as they satisfy the conditions around financial resources and sickness insurance. Economically inactive persons not regularly residing after 3 months who don't have sufficient resources or sickness insurance can be expelled if they become an unreasonable burden on the welfare system of the host member state. We said earlier that being a burden essentially consists in claiming welfare benefits. The reason for this is that the host member state does not want to pay for economically inactive citizens of another country. However, expulsion must not be the automatic consequence of a mobile EU citizen and his or her family members having recourse to the host member state's welfare system. However, it is the case that if a mobile EU citizen without sufficient resources applies for welfare benefits, they may be regarded as a burden. Let's take the case of a homeless Bulgarian citizen in Berlin who does not have resources or health insurance. Consequently, she does not meet the conditions for having the right to reside in the host member state. But how can we understand whether or not she is a burden on the German welfare system? If she is not using any support services or emergency shelters in Germany, and she's not receiving any welfare benefits, she cannot be considered an unreasonable burden on the welfare system of the host member state, and therefore she cannot be expelled. However, if she is using publicly provided support services or emergency shelters, she may be considered an unreasonable burden and therefore may be expelled. So, when and how can national authorities check whether a mobile EU citizen is regularly residing? The burden of proof is on the member state. They therefore have to prove that the individual concerned does not have sufficient resources or sickness insurance before issuing a removal order. When there is reasonable doubt, member states may verify whether or not the person can fulfill these conditions. This verification of residence rights cannot be carried out systematically. This means, for instance, that a national policy of checking the residence rights of all the mobile EU citizens found sleeping rough or all the EU migrants asking for welfare benefits in the host member state would amount to a systematic verification of EU rights that is against EU law. As we have just seen, the systematic verification of residence rights is illegal. Let's look at a real example to understand how this may work in practice. In the past, Belgium has been accused of systematically checking the residence rights of economically inactive EU migrants. Details of EU citizens who have claimed unemployment benefits are routinely passed on by the Belgian National Employment Office to the Immigration Office, which then proceeds to determine whether action can be taken to put an end to these people's right of residence. So, when do mobile EU citizens become an unreasonable burden? Let's go back to the concept of being an unreasonable burden. We said that inactive mobile EU citizens with no resources or sickness insurance may only be expelled if they are an unreasonable burden on the welfare system of the host member state. We also said that this generally meant EU citizens claiming welfare benefits in the host member state. In assessing whether an individual who has been awarded welfare benefits is an unreasonable burden, public authorities must carry out a proportionality test, which features 3 sets of criteria. Duration. How long is the benefit award? Is it a case of temporary difficulties? Is it likely that the EU citizen will no longer need the safety net soon? How long has the person been resident in the host member state? Personal situation and individual circumstances. What is the EU citizen's level of connection with the host member state society? Are there special considerations as regards age, health, family, or economic situation? Amount. What is the total amount of aid granted? Does the EU citizen have a history of relying heavily on welfare assistance? Has the EU citizen contributed to funding the welfare system in the host member state in the past? Let's look at a case study of someone who was regarded as an unreasonable burden. A Polish citizen moved to Belgium and found a job in the construction industry. After 15 months, he was made redundant. He then applied for welfare assistance that was granted. However, the Social Security authorities sent his details to the Immigration Office, which served him with an order to leave the territory because he did not have sufficient resources and was regarded as an unreasonable burden on the welfare system. Even though in the end he was not deported, he was deregistered and lost his Social Security number and access to health insurance in the host member state. Let's move now to the last grounds that may justify the expulsion of mobile EU citizens. Abuse of rights, as is the case for public policy and public security, may be used to justify expulsions of any mobile EU citizens, irrespective of their status or of the length of their residence. When might mobile EU citizens be accused of abusing the free movement rights to which they are entitled? Essentially, this is where EU citizens move with the sole purpose of evading national law by invoking their rights under EU law. In practice, this clause has mainly been shaped to prevent third country nationals resorting to sham marriages, entered into solely with the intention of enjoying the right to free movement and residence, or using falsified residence documents. We will not discuss why the EU legislator allows national authorities to use abuse of rights as a grounds for expulsion. Rather, we will look at the interesting use member states have made of the large leeway offered by this clause in order to restrict the free movement rights of mobile EU citizens. The UK, for instance, used abuse of rights to target homeless people. This example relates to the time when the UK was still a member of the European Union. How was abuse of rights used in the UK? Under a policy published in 2017 by the UK Home Office, rough sleeping could be interpreted as a misuse of EU free movement rights, and therefore EU citizens encountered sleeping rough could be removed from the UK. Rough sleeping cannot be regarded as an abuse of rights under EU law. An interpretation of the concept of abuse that includes rough sleeping is outside the actual EU concept of abuse of rights. That, as we've just said, mainly targets marriages of convenience and falsification of documents. Rough sleeping, even as a consequence of exercising free movement, cannot be regarded as an abuse of EU rights. Homelessness charities reported a sharp increase in the number of mobile EU citizens often legally residing in the UK, being removed on the grounds of misuse of rights because they were found rough sleeping. This policy was recently found to be unlawful by the UK High Court. Let's look at a different application of this concept in France. According to French immigration law, when the authorities suspect that a mobile EU citizen moved to and settled in France with the sole intention of benefiting from the French welfare system, this may justify their expulsion on the grounds of an abuse of rights. Legislation like this speaks to the claims by populist politicians that migration is simply driven by the opportunity to enjoy more generous welfare benefits in richer EU member states. However, fortunately, this legislation is also against EU law. As we have said, abuse of rights only covers fraud, falsification of documents, and marriages of convenience. Under the same French law, repeated short-term stays, going in and out of France repeatedly, with the goal of maintaining the 3-month right to stay, may also amount to an abuse of EU free movement law. This could be in line with EU law, but only a case-by-case assessment that demonstrates that the EU citizen conceived an artificial arrangement in order to renew their right to stay can justify their expulsion. We have discussed the 3 main grounds for expelling mobile EU citizens, and we have also seen how these grounds apply differently depending on the status of the person in the host member state. Is she a worker? Is he a family member? And on the length of stay in the host member state. Has the person just arrived, or are they a permanent resident? Let's now try to summarize all this information in a few tables. Firstly, what happens during the first 3 months? Inactive EU citizens receiving welfare benefits are the only EU citizens that may be expelled on the grounds of loss of residence rights, provided that they are receiving welfare benefits and are therefore regarded as an unreasonable burden on the welfare system. All other EU citizens may only be expelled during the first 3 months on the grounds of public policy and security, or abuse of rights. Secondly, what happens between 3 months and 5 years of residence in the host member state? Again, we must make a distinction between legal residents and mobile EU citizens who don't have status. Only those who have a status that grants legal residence are protected against expulsion for loss of residence rights. Inactive persons without resources who are not workers or self-employed persons, have worked for less than a year and the 6-month period has ended, or are not seeking work or do not have a genuine chance of being employed, may be expelled for loss of residence rights if they are considered an unreasonable burden. The assessment of this condition must be carried out on a case-by-case basis. Expulsion must not be the automatic consequence of having recourse to welfare assistance. These citizens can also be expelled on the grounds of public policy and security, or for an abuse of rights. Job seekers. If job seekers can demonstrate and provide evidence of job seeking and of having a genuine chance of being employed, they may only be expelled on the grounds of public policy and security, or for an abuse of rights. Formerly active persons, i.e. former workers or self-employed people, may not be expelled on the grounds of loss of residence rights as long as they retain their previous status. As long as they retain worker status or self-employed status, they may only be expelled on the grounds of public policy and security or for an abuse of rights. Workers and self-employed people. As long as they keep their job, workers and self-employed persons may only be expelled on the grounds of public policy and security or for an abuse of rights. EU citizens with sufficient resources and insurance. As long as they are registered as having sufficient resources, EU citizens with sufficient resources and insurance may only be expelled on the grounds of public policy and security or for an abuse of rights. Finally, EU citizens and their family members who are permanent residents, that is to say they have been legally residing in the host member state for more than 5 years, may only be expelled on serious grounds of public policy and security or for an abuse of rights. EU citizens and their family members who have been legally residing in the host member state for more than 10 years may only be expelled on imperative grounds of public security or for an abuse of rights. Thank you for listening to our training modules. This is the end of the last module. We hope you have enjoyed learning about EU free movement and that this guide will help you in your work with destitute mobile EU citizens. You can listen to all the modules again on FEANTSA's YouTube channel.